The evolving landscape of corporate compliance, a UK perspective. In the realm of corporate crime prevention, the UK has embarked on a transformative journey. With the 15-year anniversary of the UK Bribery Act 2010 and the recent introduction of the Economic Crime and Corporate Transparency Act 2023, ECCTA, the nation's approach to corporate crime has evolved into a sophisticated failure to prevent regime. Amidst this backdrop, the Serious Fraud Office, SFO, has unveiled an updated guidance document, offering a fresh perspective on evaluating corporate compliance programs. This article delves into the practical implications of this guidance, exploring how it influences legal outcomes and provides a roadmap for corporations to enhance their compliance strategies. Unveiling the SFO's refreshed guidance. The SFO's updated guidance, published in November 2025, serves as a comprehensive roadmap for corporations navigating the complex landscape of compliance. It clarifies the SFO's evaluation process across various scenarios, including investigations, prosecution decisions, deferred prosecution agreements, DPAs, and sentencing. This guidance is a game-changer, offering clarity on how the SFO assesses compliance programs and the factors that influence legal outcomes. It's a must-read for any corporation looking to strengthen its compliance posture and navigate the evolving regulatory expectations. Scenarios and themes, a holistic approach. The San Francisco Airport outlines 6 scenarios where a corporate compliance program will be scrutinized. These scenarios inform critical decisions, from prosecution under the full code test to the terms of DPAs and the potential for statutory defenses against bribery and fraud charges. Evaluation is a nuanced process, focusing on the practical effectiveness of controls and the leadership's role in fostering an environment that prevents fraud and bribery. The SFO's approach is holistic and fact-specific, moving beyond mere policy existence to assess real-world impact. Practical insights and the SFO's methodology. The updated guidance provides valuable insights into the SFO's evaluation methodology. It acknowledges that isolated compliance failures don't automatically render a program ineffective, emphasizing the need for a holistic view. The document also sheds light on the role of DPAs and monitors, offering clarity on how the SFO considers remedial commitments and proportionate monitoring. Legal analysis, impact on key outcomes. The guidance has significant implications for legal outcomes. An ineffective program at the time of an offense may tilt the scales towards prosecution, while genuine remediation and a proactive, effective program can work in a corporation's favor. Program effectiveness is a key factor in DPA eligibility and terms, with the SFO potentially requiring enhancements to policies, controls, training, and independent monitoring. For statutory defenses, the focus is on adequate and reasonable procedures, with organizations expected to demonstrate a risk-based, proportionate approach to compliance. Sentencing considerations. Courts can consider the existence and nature of a compliance program as a mitigating factor. This is particularly true when a corporation can demonstrate a culture, governance, and operational framework designed to prevent misconduct and show measurable improvements post-discovery. Convergence with international standards? The SFO's guidance is compared to the U.S. Department of Justice's DOJ evaluation of corporate compliance programs, ECCP, which is known for its clarity and operational framework. While the SFO's approach aligns with the UK's principle-based tradition, there are signs of convergence, particularly in the emphasis on practical effectiveness and the growing role of technology and data. Some argue that a more structured, question-led framework akin to the DOJ's ECCP would benefit UK corporations, facilitating planning and internal audit. However, the SFO has yet to adopt such an approach, leaving many corporates yearning for a clearer articulation of expectations. Statutory guidance, a case for updates. For multinationals, interpreting adequate or reasonable procedures remains a challenge. The SFO's guidance provides a high-level summary of the 6 principles, but detailed statutory guidance is scattered across various documents. The absence of an updated Bribery Act guidance comparable to the failure to prevent fraud guidance raises questions about the timeliness of regulatory updates. The evolving compliance tooling and risk landscapes underscore the need for contemporary guidance that aligns with current market practices and global expectations. Practical steps to meet SFO expectations. To align with the SFO's expectations, corporations should refresh their risk assessments through a benefit of fraud lens, identifying potential fraud benefits and extending assessments to associated persons and group entities. Map policies to controls and evidence operation, creating a risk control matrix with defined metrics and testing operation through various methods. Strengthen third-party governance by updating onboarding, contractual clauses, and ongoing monitoring to address fraud prevention obligations. Align incentives and culture by reviewing KPIs and reward structures, delivering role-specific training, and tracking speak-up data and investigations. Leverage technology by deploying monitoring tools and analytics to detect anomalies and automate evidence of control execution and policy delivery. Clyde & Co.'s perspective. Clyde & Co. emphasizes that regulatory complexity is now a strategic variable at the board level. Treating compliance as a resilience capability, driven by risk, evidence, and technology, positions organizations to reduce enforcement exposure and secure pragmatic outcomes. The SFO's guidance reinforces the importance of practical effectiveness, shifting the focus from policy existence to outcome-based assessment. This approach requires continuous improvement and agility, especially for multinationals operating within the UK's evolving enforcement landscape. Conclusion: navigating the future of compliance. The SFO's refreshed guidance marks a significant milestone in UK enforcement. Corporations must prioritize evidencing operational effectiveness, embedding proportionate procedures, and maintaining credible cooperation frameworks. Beyond compliance, it's about resilience, leveraging technology, data, and governance to anticipate regulatory expectations. While the UK maintains its principle-based approach, the convergence with global standards is evident. As the landscape evolves, corporations must stay ahead of the curve by translating high-level principles into measurable outputs and continuous improvement.